back after the lunch break. I hope you won't fall into after lunch coma, but we will do our best to avoid that. Welcome to kind of a follow-up to the session on GDPR implementation that took place before lunch at Grand Hall. Others will take place over the course of the conference on Friday in area 42 on specific aspects of the GDPR regulation, such as DPIA. My name is Michael Friedewald. I'm working for Fraunhofer Institute for Innovation, for Systems and Innovation Research in Karlsruhe, Germany. And I'm the coordinator of a project called Forum Privatheit, which has organized this panel. I will invest only a few minutes or a few seconds on presenting you. We're a long-lasting activity funded by the German Research Ministry in order to develop some interdisciplinary work on upcoming issues of privacy and data protection, to develop a modern concept of privacy, to raise attention to privacy issues, and to foster the discussion among different stakeholders. And well, Cpdp is obviously a very good place to do that. Enough for advertising. We have today a panel on the national implementations of GDPR. We learned this morning there are some activities on the member state level to adapt law, which is not so natural, since as a regulation, GDPR will be directly applicable from May on. So theoretically, at least. In the beginning, maybe you recall that the European Commission wanted to spell out some of the details of the GDPR directly, which was not very much appreciated by the legislative bodies in Europe, and in the end, the idea was waived, and we now have some 70 opening clauses that leave some room to the member states to interpret and implement details, or to spell out some of the details of GDPR in their own way. So in turn, we have a situation where member states, on the one hand, have a minimal obligation to adapt their national laws, and mainly to waive all the old legislation that obviously is in contradiction to GDPR, but also has some room to become creative, to be more specific about some of the instruments and so forth. In the session before lunch, we learned, or I learned at least, that it's only 2 member states that have currently finished the adaptation of their national laws. That's Germany and Austria, and France is very close to finalizing. I was surprised because others are obviously lagging behind, and it's quite difficult to get information about the overall status of the national implementation process. The last figures that I have been from October, and back then, well, some 30–40% of the member states were quite at the beginning of the whole process. In that respect, the implementation process is not very much different from the situation that we learn from the press that companies are in to become GDPR ready. So, though it would have been nice to talk to one of those about some of the countries that are at least a bit lagging behind, we will now present some info about the processes in some of the forerunner countries. Well, I think there are a couple of issues that will be interesting, nevertheless, to be learned. One of our speakers, who is also in the Forum Privatheit, Privacy Forum project, and will start with his presentation immediately, has written a policy paper that you can find in your conference bag. Well, maybe I can just move on and introduce our panelists. The first speaker is Christian Geminn, who's a lawyer who studied in Mainz and at De Montfort University in Leicester in the UK. And he's now the managing director of the project group of constitutionally compatible technology design at the University of Kassel. And he will talk about general patterns that are visible in the implementation process on the national level. Second presentation will be from Karolina Mojzesowicz, who is deputy head of unit at the unit responsible for data protection at DG Just. And in that respect, she's the person that also is responsible for taking care of what's happening in the member states, and if the developments there are in line of what the Commission originally had in mind. Then we will have a presentation about France, which will be given by Olivia Tambou, who's an associate professor at Paris-Dauphine University and specialized in European law, and she's currently doing a study on this implementation process in France. And finally, we have here Günther Leissler, who is a lawyer at the Attorneys at Law Schoenherr in Vienna, and he will also report about the Austrian process and all the pitfalls that it points from a very practical perspective, as far as I've heard. And the discussion will finally moderated by Wouter van Holst, who will introduce himself.
The hat I'm wearing here is that I'm with a small Dutch NGO which mostly focuses on freedom of expression. It's called Vrijschrift, and it's a member of EDRi. That's how I ended up on this panel as a moderator.
So, and Christian, the floor is yours.
Okay. Thank you very much, Michael. I would like to jump right into the matter and say that contrary to initial expectations, the GDPR establishes a co-regulation between the European Union and its member states. This is the result of the original draft being stripped of most of the powers for implementing acts and delegated acts that the Commission had envisioned for itself. The GDPR stipulates the goals and fundamental principles, basic rights and duties, as well as the fundamental structure of the enforcement of data protection within the European Union. But it also contains numerous opening clauses as well as implicit possibilities for regulation for the member states to utilize. The opening clauses can be categorized as regulatory mandates and regulatory options. Regulatory mandates are opening clauses which obligate the member states to adopt certain provisions. One example is Article 51 GDPR on providing an independent supervisory authority. In contrast, regulatory options are opening clauses which allow the member states to create their own provisions or to maintain existing provisions if these provisions do not come in conflict with the regulation. One such clause is Article 23 GDPR, which allows for restrictions of the rights of the data subject in certain circumstances. Regulatory options, as well as the implicit possibilities for regulation, bear the risk of legal uncertainty, since they may lead to a complex and intransparent situation in which it becomes difficult for controllers and data subjects alike to discern which provisions are relevant to them. They also hamper the harmonization of the legal framework in the member states. They can, however, be used not only to take into account national characteristics, but also to create a legal framework that is more risk adequate than the regulation itself. Unfortunately, the range of the regulatory option is unclear in many cases. This is making it difficult for member states to take advantage of them. A regulation which addresses the difficult issues of data protection law conclusively, or a directive which creates a clear division of tasks between Union and member states, would have been preferable to the current situation. But due to the fact that the monopolization and centralization of the advancement of data protection law was prevented, the current situation at least offers the chance to test the possibilities of a meaningful division of tasks and responsibilities between the Union and the member states. In the face of the diversity and dynamics of future and yet unknown challenges of information technology and its application to fundamental rights, the regulation, in the form in which it has become law, enables the member states in many places to experiment with different regulatory concepts. This way, a number of sources can contribute to vivid data protection within the Union. Indeterminate legal terms and their situational concretization make it possible that in each individual member state, data protection can be adapted to the local requirements. There is, however, the risk that member states will use the opening clauses to effectively lower the level of data protection. In order to ensure legal certainty, enforceability, and effectiveness of the regulation, the provisions of the regulation must be accompanied by national provisions in the member state. To a large degree, this is due to the gaps left by the removal of the powers for implementing and delegated acts. Abstract and indeterminate provisions in the GDPR are in need of specification and amendment. The regulation consequently leaves implicit and explicit regulatory scope for member state lawmakers. The member states can utilize this scope in different ways. Firstly, the member states can specify abstract provisions of the regulation and thus provide standards of evaluation and for action, which the regulation often lacks. Such specifications are only permissible as long as they do not contradict the regulation. A contradiction exists where a national provision violates the regulatory goal of the regulation, but if only an indeterminate legal term is specified and the specification of that term is not reserved for a certain actor, then this specification can be used to support the regulation even if the wording differs from the regulation. Secondly, member states can substantiate and amend the regulation with national provisions which make an incomplete provision of the regulation enforceable in the first place. This is particularly the case where in the original draft the Commission intended to introduce delegated and implementing acts which then were removed without any kind of replacement. Then, the completion and amendment of incomplete provisions, as well as the closing of regulatory gaps, enable the execution and enforcement of the regulation by the supervisory authorities and the courts. The same applies when national provisions create the necessary regulatory framework for the execution of the regulation, or when national provision adapt the regulation to the national systematics and the national use of language. And thirdly, member states can make use of any of the 70 opening clauses of the regulation, which gives the member states room for maneuver to apply their own national provisions in accordance with union law or to create new provisions. Such opening clauses for entire sectors are contained in Chapter 9 on provisions relating to specific processing situations. In many cases, opening clauses exist in order to enable the adapting of provisions of the regulation to the specific circumstances in the member states, for instance, in Articles 9 and 23 GDPR. The regulation thus leads to a co-regulation and cohabitation of union law and national law. This creates a number of difficult legal questions on how these fields of law will interact and which law will apply in the future. In the face of these open questions, legal uncertainty arises for both controllers and data subjects. The opinions of the Article 29 Working Party and the guidelines of the board can make a significant contribution towards increasing legal certainty. They help create and secure a consistent interpretation of union law. Furthermore, legal certainty could be increased significantly if the European Court of Justice went beyond answering individual questions more frequently and instead took a stand on fundamental issues. Member states can confront legal uncertainty by adapting their general and sectoral data protection law to the regulation or by evolving it. A thorough revision of the GDPR and with it the fundamentals of European data protection is unlikely to occur in the foreseeable future. However, the European Union can regulate sectoral and technologically specific data protection. Good examples are Article 6 of the eCall regulation and Articles 8, 10, and 16 of the Commission's draft of the proposed e-privacy regulation. In the latter, the Commission deviated from the technological neutrality of the GDPR and does not apply the general rules of the GDPR, but instead creates risk-specific provisions to regulate the particular technologies of electronic communication. Should the Commission decide to create further sectoral provisions, then that would be a step in the right direction, in my opinion. Thank you for your attention.
Perfect, thank you very much. So what a negative view. Well, I will just maybe switch it off because I do not have any slides. I will just switch it off. How do I switch it off? Okay, perfect. So, what a funny term, co-regulation. I didn't know that we have it listed in the treaty, but you know, there is always a nice case to be made. It's obviously not the case. We are speaking here about a regulation, a directly applicable act. It means automatically. It's already in force, and as of the 25th of May 2018, it will be applicable, and the citizens will be able to invoke their rights in front of the national courts and in front of the data protection authorities, stemming directly from the regulation. So here, just coming back to the introduction and with the fear that only 2 member states are now so far that they already provided for that, they adopted this national laws further specifying the application of data protection rules, and in particular the laws setting up data protection authorities, equipping data protection authorities with procedural rules in order to be able to apply the powers provided for in the regulation. And, for example, in Article 85, to provide for rules which allow to set the balance between freedom of expression and data protection concerns. So again, this is a directly applicable law which automatically is a part of the national law. Now, to which extent can we speak about undermining the purpose of the regulation, because it's what I understood that you are talking about, of providing for a high level of protection of personal data throughout the EU and for providing for the free flow of data throughout the EU. I'm going here back to the legal basis on which the regulation is based, namely Article 16.2, which provides for pursuance of these 2 aims. So to which extent the fact that a member state retained the possibility to further specify the application of the regulation in certain areas, to which extent this fact undermines the 2 goals which I just mentioned. Well, from our point of view, this is not the case. So this further specification laws could, but they will not, because the Commission will be very observant there and will not step back from exercising its powers given to it under the treaty, including infringement proceedings, when the member states, within this possibility to further specify the application of the regulation in certain areas or lower the level of protection of personal data, as you insinuated it will be the case, or to undermine this idea, the purpose of provision of a free flow of personal data. So the regulation is also not a set of goals, principles, and structures. As I mentioned already in the beginning, it provides for a very clear rights and obligations which are stemming directly from the regulation and which the controllers need to abide to, and which data subject can invoke in front of the courts. Now, here you were speaking also about abstract provisions, which give, if I understood it correctly, the member states the possibility to somehow further specify abstract provision. Let's not forget it. We are speaking here about a regulation horizontally affecting really all the sectors. It goes from public administration to a small hairdresser at the street on which we are here. I even don't know what is the name of the street, I must admit, I apologize. It tackles health data to our, the data which we provide while using the internet. So in such a vast scope of the application, of course, it was very important to ensure that there are the abstract provisions which will ensure two things, namely technological neutrality of this regulation, the possibility for data protection authorities, and then for the board, ultimately for the national courts and the European Court of Justice, to interpret it further and to allow the regulation develop with the development of the services which will be using our personal data. So, I think I covered already quite some of the points, but please let me know if you think that I omitted something. I would like to go back to the way we work with the member states in order to ensure that some of the things you think will happen or are happening will not happen. First of all, we established an expert group. And within this expert group, we are meeting with the member states and we are discussing which provisions of the regulation, if at all, can be further specified on the national level, how the use of Article 23 can be applied on the national level, and here we are speaking in particular with the member states about the necessity to be very precise in order to meet the requirements of Article 23 too. So it's not just a general possibility to cut down on rights and obligations every time a member state has any kind of law which pursues any of the objectives of Article 23. It needs to be a full-fledged legislation which meets the requirements of Article 23 too. I do agree that even the member states who already adopted the specifications laws on the national level do not necessarily meet all this requirement, but I think this is another story and I wouldn't like to comment on it now. Now, and there I think is also a lot of misunderstanding about what are these opening clauses. There are no opening clauses from the point of view that they are taken outside of the application of the GDPR. These are areas where the European legislators tells the member states, here you have the set of rules, the framework. Within this framework, in this particular area, you can further specify it by always observing two principles. And the principle, a part of this never lowering the level of protection of personal data and ensuring free flow of data, there is also an element of never falling below the level of protection provided for in Article and the case law, which the courts in Strasbourg and in Luxembourg developed on the basis of Article 8 of the Charter. So this is one thing. Now, the worries about, so many further specifications on the national level, it will be so disharmonized, we are undermining everything. This the regulation provides for a very specific means of cooperation also between data protection authorities so that this does not happen. The whole procedure under Article 60, namely the so-called one-stop shop, the consistency procedure, and the dispute resolution under Article 65, so the possibility for the board, for the European Data Protection Board, with the 28th still data protection authorities to take a decision, a binding decision addressed to the concerned DPAs in order to provide for one coherent interpretation of the application of the regulation in the specific cases, I think will ensure that the regulation is interpreted and applied in a coherent way. So this is where we are coming from, the Commission, and how do we see it. I think this possibility, and I underline, it's the possibility for the member states to use this, some further specifications in some areas, because as you rightly mentioned, the obligation to provide for something is really to be found and pinpointed in the regulation on only very few articles, will be exercised with some self-restraint in order to be able to not to undermine the aims which the regulation pursues. And as I said, the Commission will remain there very vigilant so that the purposes of the regulation, of the full harmonization, are not undermined. And here I would again like to draw your attention to the recitals of the regulation itself, where actually in a little bit more condensed way, this is what it says. It's recital 8, 9, 10. What was the reason to move from the directive to the regulation? To get rid of the fragmentation. What can and should be done by the member states while using the possibility to further specify the application of the regulation in certain areas, and how this further specification must look like. So, and here it's the plea and what we are doing with the member states, the whole exercise within the expert group and in bilateral conversation is always, first of all, to revise what they have already now on the national level, to repeal the legislation which is obsolete, not to repeat the content of the regulation. Therefore, I was a little bit, again, surprised by this formulation of core regulation, and to focus on not undermining the aims pursued by the regulation. I think I will finish that. Thank you.
Okay. May I? Of course. So I don't know. Okay. So I would like to go further and to start by giving some remarks on the form, on the French Gdpr adaptation. Then I will give a general overview of how France plans to make use of its margin of maneuver. And finally, I will get into some specific illustration of the French use of some opening clauses, which raise questions. So my first point is regarding the formal approach chosen by the French government. France decided to adopt one build for both the adaptation of the Gdpr and the transposition of the Police Directive. This build was adopted last December, and part one contains common provision for the adaptation of the Gdpr and the directive and the Police Directive, and part two focus on the use of the margin of maneuver, and part three deals with the transposition of the Police Directive. The implementation of the data protection package will take the form of a review of the Data Protection Act of 78. The government intends to proceed into three different stages. The adoption of a new data protection law before the next May 25, which will amend the Data Protection Act of 78, and the parliamentary discussion bill was started yesterday in the Commission of the National Assembly. After this first stage, we will have the government will have the delegation of a lawmaking authority for 6 months to rewrite with an ordinance the Data Protection Act of 78. Simplification and consistency and extensions to the overseas territories are the main arguments for the use of these techniques. At this time, it is not clear in what way it will harmonize domestic law in subjects which are not in the scope of the implementation of the Gdpr or the directive. Apparently, the drafting of this ordinance is fairly advanced, but it has not been transmitted to the Parliament or made public. In addition, we will have, for the total implementation of the data protection package, around more than 10 government decrees. So 2 consequences can be drawn from this French approach. First, we will be late for the transposition of the police directive, and which will be supposed to be on the next 6 May, and the stakeholder may not have clear access of the Gdpr implementation or adaptation rules in France before May 25. This creates some legal uncertainty. Secondly, the current bill is unreadable. It is a compact text. I'm sorry, I'm sure you doesn't agree, but I read it. Yeah, it is a compact text about 24 articles with 54 cross-references to the Gdpr disposition, including in the part focused on the transposition of the directive. Those you really need to really read carefully both build and the Gdpr in order to understand what rules apply. This brings me to my second point, and I'm sure you will be happy with that.
Thank you.
France has used its margin of maneuver in moderation. The bill respects the rationale of the Gdpr reform, both by the development of the power of the CNILs and the limitation on the prior formalities. For example, the CNIL will have a direct power for certification. The agent of the other DPAs will be able to participate actively to the joint operation with the CNIL agent on the French territory. And the CNIL, that is important, will have the possibility to join a periodical penalty with a maximum limit of 100,000 per day, euros per day, to administrative fines. However, it will not be possible to impose administrative fines on public authorities. The CNIL also obtained the right to appeal to the judges in 2 cases. The first is what we can call the Schrems case situation, when the CNIL received a complaint from a data subject about the validity of an adequation decision. And the second is to order to present observation before the judge in the litigation regarding the Gdpr. So in addition, only processing on genetic biometric data of the state acting in the exercise of its public powers will need prior authorization. To conclude this short overview, the French implementation illustrates the increasing simplification of the data protection law. National data protection law is transformed in a law dealing with specific processing, such as processing on health data, criminal offense data, the national identification number, processing in the context of employment or for archiving purposes in public interest, scientific or historical research purposes, or statistical purposes. My last point, I'm a little bit lost with my slide. My last point will be on the 3 specific uses of the margin of maneuver, which are the core of the French discussion on the implementation of the Gdpr. So first, France has added a provision regarding the law applicable in cross-border cases in the exercise of the national margin of maneuver. The bill used the residence criteria in order to protect the fundamental rights of the data subject. The bill provides an exception for processing carried out for journalistic purposes. In this situation, the establishment criterion will apply. This could produce conflict with member states which will use an alternative criterion. And this could create, I say could, sorry, don't be nerve, this could create fragmentation of the territorial scope of the data protection rules. Secondly, I would speak and I will share with you my concern or the concern about the provision on automated individual decision, which adapts the Article 22 Gdpr. I don't know if I can. Well, so the current wording provides a legal basis for a systematic use of administrative individual decisions solely based on automated processing. So I tried to make a private translation of this new approach of the Article 10 of the French Data Protection Bill. You have that on the slide. We can see that there are 4 safe measures are provided. Some are not included in this text, but are derivated from former law. First, safeguard measure, providing prior information to the data subject about the logic of the algorithm. And the second measure, a right to appeal against such administrative decision. And third measure, the exclusion of such automatic decision for processing of sensitive data. And the last measure, an obligation for the controller to have the control of the algorithm on its development. There is nothing about the use or not of this kind of administrative automatic decision measure on children. This new Article 10 do not refer to the right not to be subject to a decision based solely on automated processing, including profiling, and to the right to obtain human intervention on the part of the controller. It seems to consider that the obligation concerns only the contractual or explicit consent derogation according Article 22A or C, but not the situation of a legal derogation from Article 22B. It is true that Article 22B only refers of the need to lay down suitable measures to safeguard the data subject rights and freedom and legitimate interests. However, this interpretation is questionable. Third, I thought I have to share with you one regret, but maybe I have some hope, because the bill does not include the possibility of the collective action for damage. In other words, the margin of maneuver laid down by the Article 80 Gdpr has not been used. Those collective actions in France remain limited to the cessation of violation without the possibility of obtaining compensation for damage. But yesterday, the rapporteur, Paola Forteza, proposed such an amendment, so it will be interesting to follow how the Parliament will amend the bill of the government. It is political and legal. Political and legal margin of maneuver seems to be very narrow. Thank you for your attention. And my last slide, because I always put something of Star Wars. Thank you for your attention.
Thank you very much. I'm more than happy to share with you my thoughts from the Austrian perspective on this. As you have already heard earlier this session, Austria has implemented a national adaptive law to the GDPR, and the road to that national law was quite rough. It was in fact that last year, around May, we saw the draft legislation about national amendments to the GDPR. And during the consultancy proceedings of the draft legislation, the Austrian government broke up, and we moved in a phase of pre-election and, let's say, politically characterized legislators movement, which means that we, for establishing the draft legislation as it has initially been designed, would have needed a 2/3 majority in the Austrian parliament because it holds some constitutional provisions. Due to the fact that the Austrian government has broken up, the parliament could not achieve this 2/3 majority. So this draft legislation was again withdrawn, and it was replaced by another draft legislation that could have been passed and finally was passed on without a 2/3 majority. And the trade-off has been that while the very first draft legislation completely was designed to remove the existing Austrian Data Protection Act, it was now the case that those constitutional provisions of the very first of the existing Data Protection Act still linger on and are implemented in the draft legislation. So we have a hybrid, we have a mixture now between existing law, the existing Data Protection Act, and the new amendment to the GDPR. And it has some legal impact I will share with you. And with this, I will also share with you the considerations why Austria has decided to take advantage of those opening clauses. It has always been, and maybe still is, a particularity that Austrian data protection law not only protects personal data of individuals, but also of legal entities. And that was one of the key topics that was identified in order to put in place this adaptive legislation in order to harmonize. It was the intention to remove personal data protection for legal entities and to follow the path of the GDPR, that also in Austria it's clarified that only individuals' personal data is protected. This trade-off I was addressing just before, now with still having parts of the existing law in place in our adaptive legislation, has put up some discussions whether, although it was not the intention by the legislator, but rather caused by the facts that came in, whether even under this adaptive legislation, also personal data of legal entities persists to be protected. That's now currently under discussion in Austria. And when talking about existing law and future law, amending law, in terms of timing, it was that this adaptive legislation was issued by the Austrian Parliament back in July 2017, and it will get enforced by 25th of May 2018 simultaneously with the GDPR, and as said, it will still hold those parts of the existing law. So that's a kind of a hurdle, something how reality can come in and might even interfere with the theoretical plan of the legislator. On another note, also to give some good picture about how a member state can identify need for national adaptation, just to give you an idea of the hit points of this law, Austria has designed a specific obligation, a specific data secrecy obligation that is already placed in the now existing law and will be part of this future amendment law to the GDPR, which basically says a data controller and its employees have to keep confidential its personal data at all times. And correlating to this, the Austrian legislator also has imposed a sanction regime, specific administrative fines of up to 50,000 euro if somebody infringes this obligation. So that's a setup of secrecy obligation, and combined with sanctions on a national level that's added to the GDPR standards. Another point of adding CCTV regulation. We have separate CCTV regulation in this national law. I'm sure you're all familiar with the GDPR being silent on CCTV, so we have specific regulations there. Stuff like you must not store CCTV data longer than 72 hours unless you have need for doing so. If, for example, you get involved in proceedings where you need this as providing evidence. But that's just to give an indication where this needle goes to. Not very surprisingly, in light with the German situation, where Germany has a specific employee data protection law, it was also in discussion whether Austria should put in place something similar. It was not the case. Instead, what was put in place is a reference, a general reference to Austrian labor law, by basically referencing that this labor law shall in future be qualified as GDPR standards under Article 88 of the GDPR. So it's a very generic reference to a legal field, to the Austrian Labor Constitutional Act as a whole, and that shall count as GDPR standard in the future. This adaptive law also addresses the field of DPOs, but not by establishing specific thresholds or something like that, but it provides some, I would call it, extended privileges of confidentiality. The law basically says if an individual turns to a DPO and tells that DPO certain aspects, and if that individual is protected by specific confidentiality privileges by law, for instance, if it would be the case with an attorney is covered by statutory confidentiality privileges, those privileges will linger on and will apply to the DPO as well, so the DPO will benefit from the same confidentiality standards. And also it is clarified that the DPO must not be subject to instructions given by the board of the company. Similar to the French concept, also in Austria, the police directive was implemented through that single act as well. And also another particularity for Austria, in Austria, it's the case that we have an administrative criminal law that for ever since allowed imposing fines only on individuals, not on legal entities, and to ensure a fair principle of law application. It was clarified that if fines imposed under the GDPR will be imposed in Austria on an Austrian data controller, that this can and shall be the legal entity by itself. The legal entity shall be the addressee of the fine, and only in exceptional cases it should be the individual working there. That was a very short summary on these overall considerations that have led to this adaptive law, which we see as by 25th of May 2018. There's a lot of legal discussions lingering around this piece of work, but maybe also for you interesting to understand it right from the beginning. It was not the aim of the legislator by calling it a just one-step approach, meaning that we only have to release one act and then it's done. Right from the beginning, it was clear that a lot of other national adaptations will have to follow. And just to give you an example, a week ago, we've seen a draft legislation from the Ministry of Interior to align their set of fields with the GDPR. Just yesterday, I was in a meeting with the Austrian Ministry of Justice, where we discussed, for instance, scenarios where one attorney approaches another attorney and asks that other attorney for data access on behalf of his client to learn about personal data from the client of the counterparty's attorney. So in short, we see attorneys using the privilege of the GDPR being unions law, trying to undermine the Austrian attorney's secrecy privilege, which is enshrined, of course, only on a statutory level in Austria. And part of these discussions with the Ministry of Justice is now to align this and to set clear that the GDPR must not be used to undermine privileges and scenarios that are established on a national level here in terms of the Austrian attorney's privilege, so that the attorney's privilege shall prevail. That's just one of many, many examples. I think we will not only be faced in Austria in the future, but in the member states, other member states as well. Thank you for that.
Thank you. Okay, thank you. I first want to take the opportunity to have our panelists respond to each other before opening the floor, and I will abuse my privilege as moderator to toss out the first question to Christian. Christian, if I understand you correctly, one of your theses is basically that because it's not really a regulation but has some characteristics of a directive, we end up not having the best of both worlds, but quite the opposite of that. And just as a thought experiment, how is the situation different, especially in Germany, now that due to the unique German constitutional makeup, we still will have different DPAs across the different länder, and how, in what sense is the coherence mechanism at the EU level more problematic than the one at the national level within Germany?
Yeah, that is actually a question that is discussed quite vividly in Germany. We have now a solution where the Federal Data Protection Commissioner will represent Germany in all matters, but that is something that did not go down well with some of the state authorities, who feel that they have more to say about certain issues. So we have a solution to this issue, to how to deal with the GDPR in that sense, and how to make it compatible with the federal makeup of Germany. And yeah, basically the solution was to give certain competences to the federal commissioner.
So basically, kind of the missing bit we have at the European level of having a super DPA.
I mean, coherence in Germany is an issue in itself, because we have to coordinate between our all in all 17 supervisory authorities in the states, and the past has shown that the opinions of these authorities in certain matters differ quite substantially. So not only do we have to be in constant contact with the authorities in other European countries, we also have to come to a consensus within the federal system in Germany. And that itself is quite complex between 17 supervisory authorities.
I would also like to ask Karolina a question. Hypothetically speaking, if a member state were to grant a blanket exception on migration data under the Article 23, the second clause, just regardless of the status of the controller, just for the purposes of migration control, what would be the hypothetical response from the Commission to that?
Well, the Commission will probably start with having a look at the law, whether it meets the conditions of Article 23.2, and whether the national legislation provided for the list, and I underline that it's a list of at least, how the member state took this into account and how it provided for how it's specified in the national legislation, this items which are listed in Article 23.2. So I can imagine that there could be maybe some problems with proportionality of the measure to begin with. Yeah, and all directly the question of the scope of the restriction, introduce safeguards, specifications to the controller. From what I understood from your example, there was none of this addressed in this blanket exception, if I understood you correctly.
I was talking about the hypothetical case.
Well.
Okay, but I'm looking forward to the Commission response to the UK. Olivia and Günther, are there any things you want to respond to because there has been a bit of a debate between Christian and Karolina already, but are there things you will want to bring up before we open the floor?
I think we're quite on the same path. We're seeing national law arising next to the GDPR, and maybe we will enter into discussions the two of you already have here on the panel when we see in reality what it means when authorities, when judges apply the GDPR and the national adaptive law and identify conflicts there.
I agree. I think that GDPR is a very nice thing, but for the effective application, it's maybe another part, and we will need two things. We will need the intervention of the DPAs for the interpretation of a lot of articles who are not very clear, and we also will need, I suppose, that the civil society used the rights that European law gives to this society. So I think, I hope that, for instance, in France, we will have a huge collective redress possible for data protection, because through this action of the data subject, we will have a real data protection law.
Okay, thank you. Before opening the floor, I want to request anyone who asks a question to the panel to just very briefly state their name and affiliation. I'm not really interested in any further CVs. And what comes after the brief introduction must be a short sentence ending with a question mark. So any statements, agreements, or thanks to the panelists, you can wait until afterwards. And here in the front, yeah, there's one. Go ahead.
Yes, hello, my name is Nikolai Nielsen. I'm a journalist at eObserver. I had a question to the Commission. Earlier today, the Commissioner Jourova gave us a press conference in which she said, I quote, if some member states lag behind and do not amend their legislation on time, it might cause some problems for the overall functioning of the GDPR across Europe. But listening to you earlier, you seem to suggest that wasn't indeed the case. Can you perhaps clarify that nuance maybe that I missed? And could you also give some examples of what some of those problems might be? And out of curiosity, we know Austria and Germany have passed its national legislation. France, I think, is coming up quickly as well. Can you perhaps give us a couple examples? Some member states are really lagging behind, they haven't done anything at all. Thank you.
Well, I will start with the easiest, the last one. As the Commissioner Jourova said today, no naming and shaming, so I will not be able to say anything about it, which member states are particularly quick, this is common knowledge, but which are particularly slow. I would invite you to have a look at the page of the expert group, where you will find a table with an overview of how the member states, by member state, how they are advancing and where they are in the process of the adaptation of this specification laws. So this is one. Second, obviously, if the member states did not adopt on time legislation, and as we said today, there are certain obligations, certain things needs to be provided for, like establishment of the data protection authority, equipment of the data protection authority with human financial resources so that it can effectively apply the regulation and effectively work with other data protection authorities within the consistency mechanism and within the European Data Protection Board. If this is not being done, that indeed this can slow down the takeoff of the harmonious application and coherent application of data protection rules throughout the EU. Because the regulation equips the data protection authorities with certain powers. But member states need to establish data protection authorities. This is the case in all the member states, but this was the regulation also as if codifies the case law of the Court of Justice as far as the issue of independence of data protection authorities is concerned. So member states, while providing in the national legislation now for how the data protection authorities are to be set up, need to observe it. And the powers to apply the powers, the procedural rules to apply the powers, and I'm thinking here about Article 58 and in particular the corrective powers, and here also in particular the possibility to impose fines. These are all, there needs to be a procedural law which allows data protection authorities to use all of this. So I think this is what Commissioner Jourova was referring to. Thank you very much.
Tobias Morsches, Datenschutzraum. My question is if there is an adoption, but it is problematic or conflicting with the GDPR, will we have to go through long-lasting court cases, or will there be an intervention or comment by the European Commission in advance, in a timely manner?
Well, the Commission will use its powers under the treaties, and one of these powers is to start infringement proceedings. The start of the infringement proceedings up until the moment when the Commission when the college takes the decision to bring a member state to the court is something, is still a dialogue between the member state and the Commission. Very structured one with a letter of formal notice and reasoned opinion, possibilities for the member states to, first of all, answer to the allegations or the concerns the Commission expresses, then maybe to adjust its national legislation before we then, in view of the answer to the reasoned opinion, before the college, I recall it's a college, I underline it's a college decision, takes this decision to take the member states to the court, because it's only the court who can establish whether the member state infringes the EU law or not. And of course, we are using within us, we are doing now within the expert group and all these bilateral contacts we have with the member states, where we were able to really in a very constructive atmosphere remove a lot of doubts, and we found a common language and understanding a lot of notions, not everything, but quite some. And just looking at which were the first drafts in Germany, for example, what was adopted at the end of the day. I think it's also a common knowledge that the Commission was very much involved in the dialogue with Germany. We were also very much involved in the dialogue with Spain, and you will see there is also some movement between what was the first draft submitted for the public consultation and what came out of it. Well, just to give two examples, we are speaking to a lot of member states. We are taking this advantage, and this dialogue, it's a dialogue between the Commission and the member states. Point. This is nothing that I'm in a position to really give details on.
Take the microphone, please.
Winfried Feil from the Ministry of the Interior in Germany. I have a question to Karolina as well, and to the discussion with Christian about the term opening clauses. I've learned already that the Commission is always talking about specification clauses, but at least when it comes to data processing by authorities, wouldn't you agree that public data processing has to be based on national law, because there is no legal basis in the GDPR. There is only the sentence that you need a legal basis for data processing by authorities. And in the German understanding, you need a specific legal basis, and that is the reason why we right now change 140 laws on the national level and maybe thousands of laws on the regional level in Germany. So at least when it comes to public data, to data processing by authorities, I would say it's a co-regulation or die-regulation, if you would like to point it. And then one further question to the term specification. Of course, yes, you're right. The GDPR uses the term specification, but there are lots of other processions, lots of other words used for that. There is derogation, there is limitation, there is restriction, and there is reconciliation used in these opening clauses. So I would say it's maybe a little bit too easy to put all these legal expressions into the term specification.
Well, as you can imagine, we would disagree. First of all, the regulation occupies the whole, as far as the application of the EU law is concerned, everything that concerns personal data. And what is left out, and it's the reason we are saying further specification, because as if the borders of this area where the member states can further specify are again circumscribed by the EU law, and in this case, first of all, by the regulation, then by Article 8 of the Charter and the case law that goes with it from the Court of Strasbourg and in Luxembourg, and the idea of free flow. So for us, it's clearly what the member states can do within the area where the regulation gives them the possibility to do so. Now, coming back to public administration, it's a discussion we had with Germany, and I think it goes back to German constitutional law, and in particular to one judgment which I unfortunately do not recall from the Bundesverfassungsgericht. For us, the Article 6(1)(e) provides for the legal basis for public administration when it processes the data when it's necessary in the performance of the tasks carried out in the public interest or in the exercise of official authority vested in the controller. And I can just tell you that a lot of member states use precisely this legal basis and allow public administration to directly apply the regulation with it. Now, this is a discussion we had with Germany. I remember what is there in the German law, and I will just leave it there. Yeah, for us. But coming back, this further specification, it's all limitations. It moves the reference point is always the GDPR. It always moves with within the GDPR, and the GDPR being really the bottom line with the possibility for certain aims within Article 23 to restrict, duly justifying it. I hope I answered to the question.
Okay, next question. Also a reminder, there are 3 other panelists on the panel.
Okay. Murat, oh no, sorry. Murat Karaboga, Fraunhofer EASY, Privacy Forum 2. Just a question, could you specify again, where is it really written down what you now said in the regulation? I think you mentioned 8, 9, and 10 of the
recitals. I
recitals?
was referring to so the scope of the application of the regulation is provided for in Article 1, but I think this the subject matter of the regulation, but the reference, what is the aim, what is the legal basis, and how this national specification law should look like, it's recital 8, 9, 10, and 12. And 12 recalling precisely what are the aims pursued by the legal basis on which the regulation rests.
But does this really refer to the specification aspect in these recitals too?
Of course. Yeah, it's our understanding, it's how we read it, because whatever the aims, if the member states use, the way we see it, if the member states use this possibilities to further specify the application of the regulation, they cannot, by doing it, undermine what the regulation is pursuing. They can only further specify it, still staying within the framework which is marked by the regulation. So high level of protection of personal data throughout the EU and not hampering the free flow of data. So
but if I may, doesn't a limitation always mean to go below the standard set by the GDPR? If you limit the rights of the data subject, and I understand that this is possible through Article 23 GDPR, then you would, in effect, go below the standard set by the regulation.
Article 23 gives the member states the possibility to restrict the application of certain rights in very specific areas, for very specific aims, and never undermining the application of Article 8 and the Charter.
I mean, the general idea has to be upheld, but I still think if a member state uses this clause to implement limitation, then he takes away rights that are present in another member state who has not made use of Article 23.
Well, I would recall that according to the regulation, it can be done only if such a restriction respects the essence of the fundamental rights and freedom and is necessary and a proportionate measure in a democratic society. So a member state, in order to be able to use this possibility, has a quite high test to meet and needs to provide for very clear safeguards to prevent any kind of unlawful access or transfers of the data which is being processed on the basis of this laws based on Article 23. So yes, I see your point, but I don't think there is some room of maneuver, but the framework as such still stays firm.
Maybe just from my side to add just one short sentence. What I see those working groups in the ministries, they're very, very cautious. Whenever they think about drafting the legislation, they're really keen on not interfering with the GDPR standards, evaluating the standards. So it's my impression that it's a very, very cautious movement on the legislators' level, and it's often thought third or fourth or fifth times before putting in a draft article that might touch the GDPR in whatsoever way. So there is some awareness on this.
In Austria, at least. Last question, because it's we're running out of time.
Very short question. There is already now a regulation about credit scoring in Germany and about CCTV in Austria. Is it a specification that is allowed, or is it not allowed under GDPR?
Well, since we have on both of these issues a very extensive discussions with the member states, I will just not comment. I will just not comment because this is something that we are very much discussing with the member states. From our point of view, the legal basis there is legitimate interest. What de facto the member states do there is to legislate using the legitimate interest as a legal basis. In Germany, it's just one article in the general law, so it's even not a full-fledged law which provides for everything. But we also we are also aware of the fact that this legislation, that what is the justification of the German legislator for it, namely because of the very specific situation in which this credit scoring agencies work in Germany. But having said all of that, we are in the discussion and dialogue with the member states concerning this articles.
Okay, we heard the bell. Thank you to the panelists. Wonderful, vivid discussion. Thank you for the audience for the questions, and enjoy the rest of the conference.
you.